Thank you, everyone, for coming this morning. We have a very, very important LEXPERT session, which is going to be taking place today. Hence the format and the size of the event, which is usually a bit smaller, but of course, given the context and given the importance of the legislative changes that are coming into effect on the 1st of June 2026. LexisNexis, as we know, of course, wants to be the most reliable source of legal paper in the region, which we want to keep doing. And therefore, we have put together an incredible panel that is going to be deep diving and navigating the UAE's new civil law, the rights, the risks, and the distant opportunities. So for this specific panel, we have, of course, a panel which doesn't need an introduction, but of course, out of courtesy, I will start. So today, our panel will be better moderated by the LexisNexis MENA Chief Executive Officer, Benjamin Filaferro. Afterwards, Dr. Habib, who I think doesn't need an introduction. Dr. T has been practicing law for over 40 years. And on the occasion of today, we will be announcing the first volume of his book on the new civil law, which will be available to everyone as of today. Secondly, we have Nathalie, Martial-Braz, who is the Vice Chancellor of Sorbonne University in Abu Dhabi. It's a great honor for actually to say. And Dr. Omar, who is a corporate partner at Squire at Boggs. So I'm not going to read all the different bios because we'll need another 20 minutes for that. But I'm going to give the floor to Benjamin, who's going to be conducting the panel today. So thank you very much. Please give them a very warm welcome.
Thank you, Vincent. Thank you all for being here, and thanks for our great panelists to join us. I will start with Dr. Habib. Dr. Habib, in structural terms, what is this new civil law about? What has been consciously kept and what has evolved?
Thank you, everyone, for joining this event. I think this shows, the number of audience today shows the importance of this code, the Civil Transactions Code. And I think we all call it, in fact, in Arabic, the mother of all laws. It's a basic foundation of jurisprudence. I go back 2 years ago. I was attending a meeting here at Emirates Towers with His Excellency, the Minister of Justice, and Her Excellency, Mrs. Mariam Al-Hamadi, the Minister at the Cabinet Affairs, who's in charge of legislation. And she asked me if there was one piece of legislation that needs to be redrafted, what that would be. And my answer, without any hesitation, was the Civil Transactions Code. It was issued in 1985. It was copied from another jurisdiction, so that adds another maybe 10, 15 years to its age. So we are talking about a piece of legislation that has been in place for now more than 50 years. The legal knowledge has evolved since then. Society has changed, economy has changed. So it's time for this piece of legislation also to change. Now, fast forward, we are today here, as Vincent mentioned, 1st of June, we will have the new Civil Transactions Code in place. I think the first question that we need to understand, is this a new law or not? I think this is the first question that we need to answer. And in my opinion, and some of the speakers may disagree with me, I don't see it as a new piece of legislation. I would call it the Civil Transactions Code 1985 version 2.0. And if one can summarize in a one sentence the difference between the 1985 law and the new law, I would say that the 1985 law was a more conservative law. Now, you can define conservative the way you want, whether ideologically conservative, socially, or whatever. And the new law has a more liberal approach. And if you can visualize the difference, I would say someone who is wearing kandora with a beard, and the new law is someone in a suit and shaved. Now, don't look at Dr. Omar. He has a beard and he has a suit, so he combines both. Now, definitely there has been few changes in certain areas. There have been certain improvements, but the core of the law, the substance, has not changed much. And there are, if you go through the law, you will find that there are three different categories. Articles that gone through zero change, so it's the same article in its textual, in its wording, and of course, with whatever direction it has. There are articles, another second category, articles which went through a kind of, I would call a stylish change. So the core of the article, the direction is the same, but the wording has changed, and instead of being in one paragraph, they have been now in numerical order, for example, and so on. And there are, of course, articles that went through substantial change in direction. So if one can, I'll try to give, for example, a kind of a high-level view of what are the main areas that went through change. First, for example, under the new law, there is no specific obligation, or no obligation on the courts to follow any particular specific school of jurisprudence. So under the previous law, judges, when the law was absent, they had to go either with the Maliki fiqh or the Hanbali fiqh. Today, the court has discretion to use any Islamic jurisprudence depending on the consideration of the public interest. The introduction of natural law and rules of justice. This is an innovation. So when the law is absent, the court can refer to the principles of natural law and rules of justice. The public order or the public policy has a better definition. I wouldn't say a definition, but it's a better definition. The problem we struggled with the previous concept of the public policy, that the 1985 law cited a few examples of what constitutes a public policy, but there was no direction. Even the court rulings didn't add much clarity. And we were, as experts, always struggling to define what constitutes a public policy and what does not constitute a public policy, and it was open for discussion. The current legislation has an improvement because there are certain elements which would constitute a public policy. For example, definitive Sharia provisions, and put two lines under the word definitive, governance principle, anzimat al-hukm in Arabic, Muslim personal status matters, and mandatory statutory rules. So at least there is some guidance for the court on which direction the definition of public policy goes. Calculation of legal time limits has moved from the lunar calendar to the Gregorian calendar. Okay, I mean, while technical, it sits what's the trend of this law. Application of UAE law in mixed marriages. Previously, UAE law would step if one party of the marriageable status at the time of the marriage was UAE national. Today, even if the nationality was acquired afterwards, provided it was retained, UAE law will step in place. In contracts, and this is an important innovation, party autonomy in determining what law is applicable to the contract. Today, the first choice is the choice of the parties. Previously, it was where the contract was not performed, was formed. Today, it's the choice of the parties. And when there is no choice of the parties, it's the place of the principal obligations of the contract. So again, the whole concept, in fact, of contract has changed. I will not dwell much into this because Dr. Omar is going to cover the contract. Protection of human physical integrity. So the law introduces a rule preventing disposition over the physical components of humans' body. This is in line with the contemporary development in legislation. Regulation of pre-contractual negotiation. This is an innovation. Again, I think Dr. Omar is going to deal with it, but previously the 1985 law dealt only with the contracts. Today, the pre-contractual negotiations have certain force, have certain element, particularly in fact in good faith. Because previously in the 1985 law, good faith only applied with the performance of the contract. And I remember very well, I was giving an expert witness before an arbitration tribunal in Paris, and the chairman asked me, so do you mean to say that in pre-contractual negotiations you can have bad faith and you are not liable? And my answer was quite clear, yes, the law does not prohibit that. It's awkward outcome, but that's the case. So today that has changed. Recognition of framework agreements, or what we call term sheets or MOUs, there is a recognition for that. And an interesting concept that has been introduced is the exploitation as a defect of consent. This is a standalone, independent defect of consent, whereby a party takes an unfair advantage of another's vulnerability. And I think this is going to be a source of many litigations to come. The law has also clarified that you can combine the prescribed compensation, what we call the diya, to the additional damages. Previously, this was not an area of clarity. Courts had different understandings. Some courts say no, diya is the only type of compensation under the law. Other courts said no, you can combine. Now the situation is clear. Assignments of rights and obligation, another innovation. So in conclusion, there are areas of improvement. And in fact, when I started writing the book, I said, okay, I will write what are the old article, new article, and my comments. But I found that the law is substantial. We are talking about at least 1,400 plus articles. It's not a simple law. And that's why, in fact, I couldn't finish the book as one. This is the first volume only dealing with the obligations. And then with 2 or 3 probably other volumes dealing with other sections of the law. And I don't think that the law can be covered, in fact, in one section or today. So I think we are just trying to give you glimpses of what changes has taken place. Thank you.
Thank you, Dr. Habib, and we'll be all waiting for the second and the third chapter of your book. Another author, LexisNexis author, is with us, Dr. Omar, who wrote a book on deadlock resolution. Dr. Omar, does a full recodification change how lawyers approach the civil code as a general law of obligation, rather than defaulting to sector-specific legislations?
I think the short answer is that a full recodification does not replace practitioners' reliance on sector-specific legislation. What the recodification has done is that it has cleaned up the general law and the general legal framework, made it more efficient, modernize it to allow it to work with less friction with sector-specific legislations. And this is important because given the UAE's constitutional and regulatory landscape and the sophistication of the business environment, it is very hard to find a law that would cover for all these specific sector areas. So it allows now, I think, in a better way, the civil code to fulfill 2 key functions for it. The first function is the gap-filling function. The civil code remains the safety net for all laws in any civil law jurisdiction. For example, if we are negotiating an SPA or a share sale and purchase agreement, a commercial lawyers or corporate lawyers' first point of touch would often be the commercial companies law. But if you consider things like the new duty of disclosure of material information, specifically at the pre-contracting or the negotiation phase, or if you consider the defects of will, these are not points that the civil code, the commercial companies law would deal with. And lawyers will have to revert back to the civil code to observe these duties and know what is the law on that. So the civil code comes with that function of supplying these missing remedies in where the specialized law does not detail. And the second function is eliminating conflicts. So the new, I think, code clarifies what is considered, as the Prof Habib mentioned, matters of public policy. It's a very important point, by the way. I'd like to add to that, what I liked about the definition of the public policy is, I think the definition, it dropped three very important topics that were in the previous definition. One is حرية التجارة or freedom of trade. That was a public policy matter. I don't know why, but it's in my view a great improvement, because it gives more freedom for trade to operate on global international standards. تداول الثروات, or the transition of wealth, is another area which is hugely linked with family businesses, transitions and structures. وقواعد الملكية الفردية, the personal ownership rights. So these are three topics that have been dropped from the definition of public policy. But that's the conflict elimination function that the civil code does, and the examples are endless. So for example, if we are looking at the muqawala contract or the contracting section, the laws, the civil codes in new methodology is very clear. It mandates specialized or local rules and makes them take precedent over contracts. So if you have a land department in a particular emirate that has specific construction regulations, those will prevail or take precedent. And if you don't have that, then you fall back on the civil code. So overall, I think the recodification of the civil code makes it more coherent, aligned with modern commercial practices and specialized laws, and allowed it to work with less friction. But the starting point of professionals will remain the sector-specific legislation.
Thank you, Dr. Omar. Professor Nathalie, how does the 25 code organize multiple legal traditions? And how does the UAE codified hierarchy compare to the French one?
Yeah, thank you very much for giving me the floor. Even I'm not a practitioner here in UAE, but for me as a French lawyer and probably as a French professor, it's particularly interesting to be here at that time. 10 years ago in France, we were discussing exactly the same topic for the French civil code, which was not 40 years old, but 200 years old, but with exactly the same problems. The problem of the obsolescence of the disposition, the problem of the adaptability and the attractivity of the rules, how to attract and use finally the rule of law to be attractive for, of course, the market and the contracts. So if you have an attractive law, you can attract contracts, because finally the practitioner will choose your law, and you will give some job for the lawyer that you train. So it's not only a question of codification, a question of, I would say, reduction and wording of the law, but it's also an economic question and, of course, a political question. So we were there 10 years ago in France discussing how we have to change the principle and in which direction we need to go with those rules, which was quite older. I would like to go to the same conclusion. In fact, the reform in France in 2016, as the reform here in the CTL, it's not a new law. It's just an adaptation of the rule which was applied by the judges, by the practitioners, And in fact, it was the jurisprudence that is codified in the rule of law. So I think that is really important, first of all, to not be afraid by the reform, because that won't be a major change in the use of the practitioner. It will be just an adaptation of what you are practicing every day. And 10 years after, I think we can see that the different rules need also time to be applied properly. In France, the reform we're discussing in 2016, but the previous, and in France, will take much more time than in UAE. Things are going much quicker here in this country. In France, we took almost 12 years to discuss the reform, to assess all the text, to ask for all the practitioners, the professors, the judges, what they think about these texts, the disparation of the cause, and all the different elements of the reform. Here, that's going much more straightforward. But at the end of the day, it will be the same. The rules will be what you are doing with it. So all the different principles that we are mentioning here will take their form and their proper application by the use that the practice is making with it. So, in fact, in 2016, when the reform was adopted by the French government, it took 2 years to finalize the reform. Why? Because, in fact, some principles, when we applied them, the practice realized that it was not so easy sometimes to apply it, to give some framework, to give some criteria, to apply them, and that needs the feedback from the practice. So, in fact, the definitive reform was in 2018 with some difference of text which were adopted. For example, the information duty was changed between the first version and the second, just to be sure that the criteria given and the charge of evidence is well adapted for the practitioner. So we had some differences that came back from the practice to be sure that the different provision adopted in the reform, because as you said, it's a major reform. It's the foundation of everything. The contract law, the transaction law, is the foundation of everything, because you need it in every part of the law. You need it for corporate, you need it for the buildings, you need it for the intellectual property law, you need it for everything. Everything you do, you are doing it by a contract. So that is the mother, I would say, of all the laws. And for that, you need to be sure that the application of the principle are well made in the code and well applied by the practitioner. Here in UAE, we have one more, I would say, difficulty, is the multiculturalism. If you see in this room, I'm not sure that we can count, but maybe we would have all the nationality in the house. So with that, we are all coming with our own tradition, our own training, and our own way of applying the law, because we don't come from the same tradition. But if we try to sum up, in fact, there is two major, I would say, law traditions, civil law and common law. And when we are presenting it for the students, most of the time we are presenting it as very different system based on very different principles. But at the end of the day, and you are the proof of that, when we apply them, it's very close. We have a lot of common principles. And in fact, this reform is trying to embed both of these traditions to be the more pragmatical and to be the more efficient in the ground for the contract you are proposing to your clients. So at the end of the day, we find many director principles that we can find in both systems. We are talking about good faith. Good faith, it's exactly the principle which is existing in both systems. The only difference is the way we will apply it in practice. But at the end of the day, we need this principle mentioned in the code. In France, we had it by the past, but not as a principle. And the major difference, it's not the fact that it is written in the code, but is the scope of this principle of good faith. In fact, the scope enlarged because we took in account the different tradition to be sure that when a French lawyer is applying the good faith, he will apply him in the same way as a common lawyer when he's discussing with him. So, in fact, we have many examples, and we will come back, for example, on the hardship later on. It's exactly the same principle. It's to be efficient in the contract. And last but not least, but the question of the interpretation. What happens when there is no rules? Because in fact, we are living in a world where in fact, everything is changing every day. And it's more and more complicated to forecast, to be well in advance, sure of what will happen tomorrow. So we need to be sure that the contract will be sure and efficient and last as efficient contract. So for that, we need to be sure that we can make interpretation later on, not at the moment we are writing and we are good friends with the different partner, but later on when we will face the difficulties, when we will have some problems in the execution of the contract. And the major difference, I would say, and is present in both reform in France and here, it's to left the literalism, I would say, of the contract behind, and to give key for interpretation. The keys are different because the culture are different. You mentioned it, the Sharia is present where in France we have a guide of interpretation. We use more the principle, we use more all the different way of interpretation around the contract than here where we go to search in the Sharia in first intention the element of interpretation. But at the end of the day, we will left the letter of the contract to be pragmatical and to be able to apply it. And for that, we have to take in account the probably most important particularism of the UAE is the difference between the different custom between Dubai and Abu Dhabi, Sharjah, and all the Emirates are not based on the same tradition. And that also something we are well custom in Europe. We are living not in France, but we are living in a federalism, a federation of 27 countries. So we need to take in account the way we will apply the law. So it's, I would say, absolutely different and everything the same.
Thank you, Nathalie. Maybe we can continue with Dr. Habib and to deep dive in some specificities of the new law. Article 390 allows court to vary agreed liquidated damages. In practice, is this judicial supervision of risk allocation or a continuity with the previous regime?
I think one of the areas that went through what I would call substantial change and which will have a significant impact on how business is conducted is previous law 390, which is now 340 in the new law. That's liquidated damages. I think for construction, we all know that it's important component of the economy in the UAE. That has gone through significant, in fact, changes, and I would believe to a large extent an improvement. It's more of an improvement. So the new civil code or civil transactions code make a clear shift from a broad judicial discretion that existed under Article 390 to a more of a defined statutory criteria in assessing liquidated damages, which in my opinion, this reflects a more of maturity phase when it comes to contract law in the UAE, balancing between the freedom of the parties to the contract and the fairness controls. So for construction, where liquidated damages or the liquidated damages clauses are, the reform directly, in fact, impacts project financing, procurement, dispute strategy, and that's important for lawyers, and also the contract drafting. So the message is simple. Agreed damages are no longer treated as automatically final. Now, will this increase legal certainty or give it or introduce, in fact, new areas of dispute? That yet to be seen. So let us now break this situation. Under the 1985 law, Article 390, courts could adjust the agreed damages with broad discretion and very limited, if any, in fact, statutory guidance. Courts retained wide discretion to adjust the agreed damages, and there was little, if any, guidance from the law as to how the court should assess these damages. Article 340 is a major improvement, in fact, and it specifies when courts may reduce or increase the agreed compensation. So, the court may reduce the agreed damages where the compensation is proven, the word proven is important, to be excessive, the obligation has been partially performed, the creditor contributed to the harm or aggravated it, and in cases of fraud or gross fault by the debtor which justifies the court intervention. Let us take them one by one because each one of these are quite important. So, excessive compensation, that's a reality check. Courts may reduce the damages proven to be exaggerated relative to actual loss. So, this means in practice that employers will need credible evidence of loss. It's not enough to say that, okay, the article says that this is my 200 or 2,000 or whatever per day. No, you need to prove the actual losses, not simply relying on the wording of the contract. So, for an industry, construction industry, this means better cost documentation. This is an essential element now. Delay damages clauses may face scrutiny in arbitration, and aggressive limited liquidated damages percentages could become harder, in fact, to sustain. Partial performance, and here I think where there is an actual innovation and a significant innovation by the law. Courts may reduce the liquidated damages clause where substantial part of the contract was completed. Now this helps and is quite relevant to phase developments, which is a kind of a popular practice here, infrastructure projects and sectional completion. So, in practice, contractors gain now statutory support where most of the work has been delivered on time. Previously, that was not the case. And employers may need more nuanced completion milestones, and project programming, in fact, and completion certifications becomes legally significant today. The other element is the employer's contributory fault. So if the employer's conduct contributed to delay, damages may be reduced or even eliminated. And this codifies a principle that already exists and is familiar in international construction practice. So, in reality, what does this mean? There is a stronger focus now on employers' decision-making, approvals, variations, and site access. Documentation discipline is critical today, and concurrent delay arguments likely to increase. Fraud, another innovation that has been introduced. Employers, in fact, may claim damages exceeding the amount that agreed in the liquidated damage clause where contractor fraud or gross fault is proven. I think this is going to be a source of substantial claims and dispute before courts and arbitration. So in reality, what this does, it removes the contractual cap in cases of serious misconduct. So what will this have in arbitration or in litigation? In my opinion, delay claims will likely become more evidence-driven. Quantum experts and delay analysts will play an even bigger role today in construction claims. And when it comes to the arbitration, tribunal analysis will shift from a more of a contractual interpretation to a more of factual causation. This will have also impact in drafting the contracts today. So standard forms of construction contracts in the UAE will need now to be updated to accommodate these changes. Now, clauses, for example, addressing concurrent delays, sectional completion, documentation obligations should be revised, and if not there, introduced. And parties should assume that courts will actively test the proportionality of the implementation. So, for employers, this means that stronger project controls are required. Evidence of factual loss will matter, and administration failure could reduce the recoverable amounts of damages. For contractors, delay analysis strategy should start during the phase of the project, not as with the practice now. After the dispute arises, they start doing their documentation. Transparency, record keeping are essential risk management tools. So, in brief, liquidated damages or delay damages are no longer the end of the legal conversation. They are the starting point for judicial evaluation based on various matters that the law has introduced. And those who adapt to the contract practices early, in my opinion, will gain a strategic advantage in their claims. Thank you.
Thank you, Dr. Habib. Professor Nathalie, in France, hardship evolved significantly in recent reforms. How does the UAE approach compare in terms of judicial powers?
Yeah, thank you very much. I think the hardship is probably one of the major innovation in the French reform and probably also in the UAE new civil code. For that, I will make my law professor just 1 second. If you remind your class a long time ago, your professor probably taught you that the contract is the law of the party and you cannot change this law because it was discussed between the parties, and so they adopted that, and that has to be performed as it was adopted. But that rule, that very major base and foundation of the civil code, was applicable in a time where we were able to plan, I would say, a long time ago, and where probably we accepted the difference in the execution of the contract. Nowadays, and we see it more and more quickly, the change of very important consequences, economic consequences on the performance of the contract. And sometimes when we are deciding something in price, for example, or the condition of the execution, 2 years ago, that won't be the same because of the weather, because of the geopolitical conditions, because of many applications, because of the disparition of the partners. There are so many obstacles that could happen in the execution of the contract. That's the reason in 2016 in France, the legislator realized that these very important rules cannot be applied as the same, and we need more flexibility in the application of the contract. But of course, when you try to embed flexibility at the time of execution, it's not the same when you are at the time of the negotiation. Because of course, when these obstacles happens, probably the parties are not so good friends and they are not able to discuss properly of the new application of the rules. That's the reason it's absolutely crucial to embed the judge in this discussion and to embed experts to bring a better evaluation of the consequences of the performance of the contract. That's the reason, in fact, in France in 2016, we adopted the hardship in our rule of law. Here, it's not only the question of adopting this hardship, but also to make it imperative. So that's a major difference. In France, you can remove, in fact, the hardship. You can accept since the beginning that you will organize the change of condition. Here, you are obliged to accept an eventual renegotiation of the contract and a change of the term of the contract. This is now in the Article 224, and the conditions are written. The conditions are described as exceptional and foreseeable circumstances, making performance excessively onerous. So we have a definition, we have criteria, and of course, the jurisprudence will define what is exceptional and foreseeable circumstances. That's the major difference within the French system is the fact that you cannot remove this condition and you cannot remove this rule. Is it a mandatory rule? Any contrary clause will be void since the early beginning. And that, of course, is important because the judge can oblige the parties to renegotiate the terms of the contract and to accept any change of the contract. The difficulty in practice will be to define, in fact, these criteria to accept the role of the judge or to finally goes to the term of the contract. In another term, the difference or the difficulties will be to make the difference between the force majeure and the hardship. In which condition the contract will be quite impossible, but only onerous, and in each condition it will be really impossible, even we are making a more onerous condition. So that is a very important shift, I would say, because in fact is the difference of political tradition that this change embed. The idea here is to be sure that the contract will be performed, that we can continue. It's based on the business continuity of the different operation. The objective is to be sure that we cannot be stopped by the end of the contract, by the termination of the contract, because the contract would be too onerous to be executed. And this is also the translation, I would say, of a major change, the change which is between syllogism and unilateralism. We accept more this, we accept more that the contract is not only the thing of the parts and the thing of the parties, because the judge can be a part later on to reinterpret, to renegotiate, and in some cases to sanction in case of abuse. So that is, I would say, the change of philosophy which is embedded in the reform of the new contract code, which is very similar with the French code.
Thank you very much. Another change, Dr. Omar, what are the key changes to the contract of partnerships, and how do they interact with the company laws?
Thank you, Benjamin. This is closer to home, closer to my domain. So excuse me for the elaboration in advance. I think, as you state, I think the Civil Code makes a major effort to modernize the partnership, the framework, and to bring it closer both to reality and the commercial companies law. So let me take you through some of the changes that in the Civil Code. The Civil Code now provides a clearer definition and distinction between commercial and civil. And these commercial, either on the basis of their nature, commercial or non-commercial activities, or simply by adopting a commercial company's legal form. This obviously helps understand which regime applies to which type of companies and reduces the ambiguity in that space. It also allows companies to reinvest their profits into their core objectives, which is also in line with the company's law most recent amendment, opening the door for non-for-profit companies. The code also now offers a greater flexibility for partners, allowing them to modernize their partnership and economic arrangements. So companies now can be either owned by a single partner, whether natural or corporate, and the profits and losses no longer need to match the contribution of the partners. So you can have a disproportionate allocation of profit and loss, which is again consistent with the change of the company's law, the most recent one where the company's law opened the door for having different classes of shares or having different price associated with the shares of the partners. That also makes partnership structures more adaptable to real commercial and professional reality. In the civil code also there is an updated section on the management and liquidators liquidation process, more rules, more structure, more discussion of the liabilities of the managers, the liabilities of directors when the manager's role finishes and the liquidator role starts. The code also offers more protection for partnerships against personal liabilities of the individual partners. So creditors of the individual partners can only now enforce against the dividends of those partners or the proceeds of the liquidation. And there was also more clarification for the grounds of dissolution in the civil code, which can be done either by unanimous agreement of the parties or by judicial judgment or in cases stipulated by the law. So the judicial dissolution itself is still tied to serious breach of obligations or material harm to the company caused by a partner, but deadlock or continued disagreement among the parties has not been identified as a ground for winding up. The code also addresses successfully, in my view, withdrawal of partners from an unlimited term partnership subject to certain controls, things like giving notice to the other parties, the absence of a fraud and absence of a harmful timing, which also allows partnerships to continue among the partners and provides a solution for disagreements among the partners. It is not a change, but in my view, it is important that the civil code also maintained what I consider creative and advanced tools for deadlocks in the civil code, the provisions that deals with withdrawal and exclusion of a minority partner from partnerships on the basis of reasonable grounds based on a court order, which also helps resolving dysfunctional partnerships and deadlocks. Another area of improvement and change was the regulation of the professional companies. So professional companies are now regulated as part of the civil companies body. And these regulations, for example, allowed participation by foreign professionals, opened the door for non-professionals such as funding investors to also be part of a partnership, and also provided non-compete obligations on the partners not to be part of a competing business. And it sets out also the duties and liabilities for the professional partners, which is also important for a lot of the professions that are not regulated by a sector regulator. Mudaraba contracts have been singled out and is no longer part of the civil companies. It has now become a standalone named contract, and it is, in my view, a very good improvement in the companies in the civil code, because Mudaraba contracts are often used informally by individuals for investment arrangements in reality. But the uncertainty for me remains in relation to how these new improvements, provisions interact with the commercial companies law, and how would the wider corporate community benefit from that improvement. And let me explain this a little bit. Article 602 says that partnership chapters shall not prejudice special laws, but it does not expressly state whether they supplement special laws when special laws are silent. And that would have been okay if we didn't have history, because we would have assumed falling back on civil companies. But the history tells us that the UAE courts have been very hesitant in applying the civil code provisions to commercial companies on grounds that these provisions only apply to civil companies, but not to commercial companies. And let me give you a directly relevant example. So, for example, we have Article 302 of the Commercial Companies Law, which states that companies can be dissolved on a judicial order. No grounds are stated in the Commercial Companies Law. The Civil Code, Article 627, authorizes the court to order the dissolution of a company on request due to a series, or request of a partner due to a serious breach of obligations or material harm to the company caused by a partner. Is this provision in the general law applicable to commercial companies, say for an LLC? Yeah. This, for me, raises the policy question, which is, are these improved partnership provisions intended only for civil companies, or should they apply to commercial companies when the law is silent? Yeah. So I think overall the civil code came with positive modernization, changes to the partnership legal framework in the civil code. But the practical challenge will be for us to fully understand when courts will use these provisions to fill the gap in the company's law, because there has been hesitation in the past. And Dr. Habib will tell you from practice how difficult it is to go to a court and try and exit a minority shareholder using old Article 667 in the Civil Code, and how much resistance there is. I'd like to maybe just end on a note. When I was preparing my book on deadlock in private companies, I came across an interesting court judgment, which was, I can't remember which court, but there was a situation of a private commercial company where one of the partners disappeared for an extended period of time. And it turns out that the partner has been implicated in a political case, a foreign jurisdiction, and sentenced for imprisonment for 15 years. The outcome of that was that the company could not manage its affairs efficiently. It could not renew its license. It could not satisfy the KYC requirements. It could not approve its financials and approve the dividends allocation. So the other partner went to the court and requested applying the civil code provisions, having serious grounds causing damage for the company, to either exit the other partner or wind up the company. And the outcome for that was resistance on the basis that these provisions do not apply to private commercial companies in that state. So that case does not justify applying the civil code. I think it is a stakeholder and policy discussion that we must have. We either have more clarity on the application of these provisions in the commercial companies law, or we consider seriously the appropriateness of these provisions and then impose them or bring them into the commercial companies law. So let's hope this will be in the next round with the commercial companies law amendments.
Thank you, Dr. Omar. Dr. Habib, do you think the greater impact will be on judicial reasoning or on how lawyers draft contracts of the different changes?
I think both, but if we put them in order, I think the draft of contracts would come after the court's reasonings, because once the courts start applying these provisions, and we are facing with new judgments on how these different provisions of the law are going to be interpreted, I think lawyers will need to go back and revisit the templates that we have to make sure that they are aligned with the new law, and they're aligned also with the directions that the court are giving. So I think both are quite important, but I think the court's role will come first and then the draft of the contracts.
Thank you. Professor Nathalie, what kind of legal training do you think is required, or change in mindset that is required with these changes?
I think nowadays the lawyer face many changes. Is one, but also the difference between the different system, between the evolution in the way they are trained. And I think it is important to embed, of course, these changes in the curriculum. And at the university, we are changing. We are very used to change and to adapt the curriculum to be sure that the classes are relevant. But as a French university here, we truly believe in the fact that we need to train more the lawyers, and I think for lawyers it's particularly true, but for all students, to train them to think and to be able to adapt for this reform, but also for the next one and for the future change of the law. And here, I'm sure that you are facing it with the young lawyer that you have in your law firm. Is it important for them to be able to use different systems, not only the UAE system, but also the English system, the French one, the Indian one, because the different partners sometimes impose the system, and you need to adapt and to create your own rules. And here in the UAE, you have to deal not only with the federal law, but also with the different offshore system and the different ad hoc system. So you need to train your students to think rather than to just apply some rules. And when they are able to think, in fact, they are able to apply any reform because they will have to sit. And nowadays, it's very easy to have the content, to have the knowledge. So with all the different AI system and probably the Lexis one, where you can find everything you want. So you don't need to have the knowledge. You need to have the capacity to take a step back, to think, and to see how you can apply it for your case and for your client. So I think it's really important, first of all, of course, to take the time to analyze this reform and to see what is changing and what will be the adoption in the framework of our contract, but that will come with the time. It's not at the moment when the reform is adopted. That will come with the feedback of the judges, the feedback of the clients, the adaptability in the ground. But it's important to train them to see how they can adapt, because at the end of the day, this reform is the results of your, in fact, thinking of the past, of your application of the former text, and the good training for the students is to being able to adapt in the future for the different change of event. So I would say that we have to take the time to think, because when it's very fresh reform, sometimes the texts are not appearing as strong or as deep as they are. We have to train them on the philosophy of the text. As I mentioned, I think there are major change, not only in the content, on the letter of the text, but on the philosophy, which is more important to see that there is a gain of efficiency, of the truly willingness of being efficient with the different provision. You showed it in the different parts. And after that, when you have to apply it, to go deep and to search the literature, to be sure that you can analyze it with the most important sources. So I think that is a Suleiman.
Thank you very much. I'd like to thank all three of you for this very interesting overview and this deep dive in this very rich reform. I would like to let enough time for the question from the large room that we have today.
Thank you very much for this valuable discussion and input. And I feel very thankful for Dr. Habib and Mulla for raising the topic of previous article 390 and the new article 340, and any practitioner who handled previously and currently major contracts like PPC. We know that it's not covering only the liquidated damages, it is covering also the indemnification scheme as well as capping liability or knock to knock. Now the question for Dr. Habib, the new article is giving a specific authority to the judge to increase or decrease the compensation. At least the previous article was a bit open when it comes to increase the compensation. So how come this is, when it comes to the application of this article to indemnification scheme and capping liability, would be an enhancement? Would be an enhancement from the previous article.
The problem with the previous article is that it opened the door, but it didn't give any direction as how the court would apply the Article 390. For example, if the court decides that, okay, the actual loss is less, how it's going to reduce the amount of liquidated damages. So the problem that we had is that you had different interpretations, different approaches, particularly that we are in a federal state, so you have federal courts, you have local emirates courts. So the practice was not unified. Today, there are certain guidances and borders. So the courts cannot completely ignore these directions. And at least there is an element of certainty that we know that, okay, these are the instances where the court can exercise its powers. The advantage of this is, in my opinion, that if, for example, the court goes out or for any reason ignores these or whatever, there is an element of control from the Supreme Court, whether it's the Cassation Court over the court. So previously, the Cassation Court would say, well, this is a factual matter. We cannot overlook or review what the lower courts have said. Today, no, it's become an illegal issue. So that will empower the higher courts to exercise its control over the direction that the lower courts taken, which leads to establish principles that can be used in future cases.
Hi, morning. Thank you for a very interesting morning. My question is in regard to furthers the group. So where we have these new provisions, taking, for example, the new 340, is it that the employer had to demonstrate that the damages are not excessive, or is it that the other side would have to show that they are?
I think it depends again on case by case. So who is the party who is making the claim? That the burden of proof lies with him. So for example, if I am claiming that the liquidated damages amount is excessive, I have to prove that the loss is, and vice versa, of course.
I just want to know, does this apply to the old contracts as they were signed before the law?
Yeah, that is a very good question, and that gives a lot of conflict, in fact. The code will be in application, will be enforced after the 1st of June. So for all the former contract, normally the former law is applied, and it's the new law for the contract conclude after the 1st of June. But that there will be, of course, a lot of provision to clarify this, because it's the experience of 10 years shows that even with the very clear rules, it will give some complication, a lot of complication in practice.
Yeah, I'd like to just comment on that. I think Dr. Filaferro kind of explained the parameters around the element of the liquidated damages. But if you actually think about what has happened, you moved from a very wide sort of discretion to slightly more controlled discretion. So even old contracts that were concluded under the old law were still falling under the broad discretion of the court. The fact that you have more structured discretion doesn't change anything in connection with these contracts. And so in my view, in that particular respect, there is probably very little to worry about from that perspective.
I would just like to add, I think, and this is a tip particularly for litigation lawyers, I think the question is not only whether the new law would apply to previous contracts or the new contracts. In my opinion, of course, from, as you said, 1st of June, it applies because the previous laws will be abolished. But the tricky issue is if you have an existing case in the court today, you need to make a revise of your strategy to assess whether it's more wiseable to fast forward your case before 1st of June, or you take a step back and try to make it slower in order that you fall under the new rule. That depends, of course, where is your benefit?
If I can add just based on the experience that we have. In fact, normally the judge doesn't have to apply in advance, I would say, the new law. So even if you have a case or the contract is concluded based on the former law, in any case, it's sure when it's a progress that the judge will make the interpretation of the former law based on the light of the new law. So in fact, it's not black and white. And we know that sometimes, and that's where, in fact, the jurisprudence and the Cassation Court, the role of the Cassation Court and the control is really important to avoid the multiplicity of the case and the interpretation of the law for this contract. And again, 10 years after, we have still in front of the Cassation Court in France some cases where, in fact, normally, if we would have applied the former law, the case would have been solved in a very easy way. But because 10 years after, we still have the heritage, I would say, the legacy of the former contract, and it doesn't make sense 10 years after to make this cohabitation, I would say, between the two rules. Some judges apply in advance, 10 years after, the new rules in a former contract. And I can assure you that is the most tricky question that we will face during the next years to know how to make the strategy in the contract. And sometimes, by some renegotiation, it could be done to say, okay, we close the former chapter and we move forward to apply the new rules to avoid any complexity in the future. That could be also a strategy to avoid that.
First of all, thank you very much for the openness to putting this panel together. I think this year will be a year full of substantive law conferences, which is a sight for sore eyes, I think, in this region. In terms of the question, I looked at the new civil code and I wondered, those things that are not there or had not been changed or had not been clarified, and just wondering what you think of these. One of them is the enforceability of contractual time bar clauses. So FIDIC for Grade 1 as an example. So I think common belief is that under the old civil code, that such clauses were unenforceable because of the provision of the law which says that you cannot modify a time bar by contract. And I'm wondering that this will continue to be the case. The other one is, if you look at the provisions on tortious liability, there's a set of rules on direct versus indirect causation, which has its historical roots, but it's fairly difficult, I think, to apply in practice. And courts in this country rarely sort of go and analyze specifically whether a particular harmful act was caused directly or indirectly. The examples that are given in the MOJ commentary, if you cut a rope, it's direct causation. If you cut a rope with the lamp falls, the hanging on the rope, it's indirect causation, for example. But if you try to apply that to banking transactions or to transaction maintenance, it's far more difficult to do. And the third one is the distinction between the concepts of rescission and termination, because they are just in the same provisions.
I think, of course, these are very relevant questions. And this takes us back to the first one I mentioned, that this is not a new law. It's an improvement or a new version of the existing law. So there are areas that has been, in fact, affected by changes. And there are areas that were kept for reason or sometimes for no reason. But I agree, these are areas that needs some sort of clarification. And I think from an interpretation perspective, we are one step now back, because with the 1985 law, we had the Ministry of Justice commentary. So it would shed some guidance on how the different provisions would be construed. Today, we don't have that. So we will have to wait until the courts interfere and explain these issues. Now, for example, if I had to deal with the drafting of the law, I would have done it differently. One of the areas that, for example, I would have done is that go through all the cases that as the courts have passed in the past 20 or 30 years, because those cases shows the issues where there were issues with certain provisions and there was no clarity. and try to address them. I don't think that exercise has taken place. So your questions are valid, and I think we'll continue with them for a while.
If I can add a word, I think any reform won't solve all the problems. As some of them stays, and I think it's a good thing for us, because if everything was solved, we don't need more lawyers. So that's great that we need to have some clarity and interpretation made by the practitioner and probably by the doctrine and the judges.
All right, thank you very much for today. I would like to congratulate again Dr. Habib on his new book. And of course, to thank again all our panelists for all these insights. I mean, we have to stop now. I mean, I think we could do like a series as well of on the same topic, because it's a very rich reform. So if you can join me and applaud our panelists. Thank you.